My name is Robert Pearce, and as I've discussed in other videos, some brokers have been terminated, have had vindictive employers make false statements on the Form U-5 termination notice, particularly in connection with the explanation given for the discharge with cause. And the remarks on that U-5 and on your CRD and your broker check are permanent unless they are expunged. And they're visible to the world via the internet forever until they're expunged. And in some of those cases, the only way that we can get rid of that false and defamatory remark is by filing an arbitration claim against the broker-dealer. Now, the claim is for defamation. And what is defamation? It's the brokerage makes a false statement. The statement is defamatory, meaning that in this context, that it affects your business reputation. It's published to the world through the internet. The statement is made either negligently or recklessly, and you're harmed. That's a false and defamatory statement that constitutes the elements of a defamation claim. Now, some states, no matter how malicious the broker-dealer may have acted, no matter how much that statement may have hurt your reputation, you can't file a defamation claim. And that's because those remarks on the Form U-5 have been held in those states as absolutely privileged. They have absolute immunity. Two states that come to mind where that defense has been published time and time again in the court opinions are New York and California. On the other hand, there are many states, and it is the majority view, that those statements are not absolutely privileged. The broker-dealer doesn't have absolute immunity. Rather, those statements are qualifiedly privileged, meaning that if they were made in good faith, with a reasonable basis, then they could be protected. But if they were not, if they were made willfully, wantonly, maliciously by the broker-dealer, they won't be protected by the qualified privilege. Now, some courts have expressly held that, and courts in the states of Arizona, Connecticut, Florida, Illinois, Michigan, Oklahoma, Tennessee, and Texas have all said that the defense is only a qualified privilege. 11 other states in another territory have enacted what's called Section 507 of the Uniform Securities Act, and held, by adopting that statute, it's codified that the privilege is only qualified. And those states are Hawaii, Idaho, Kansas, Maine, Minnesota, Missouri, Oklahoma, South Carolina, South Dakota, U.S. Virgin Islands, and Vermont. In those states with a qualified immunity, qualified privilege, a broker can sue his employer for defamation. And if the firm knew that the statement was false, or should have known that the statement was false, or made the statement with reckless disregard as to whether it was false or not, they can be sued for defamation. And once you sue them for defamation, you can get your damages, the damages to your business reputation. But you can't do this on your own. You need to hire a skilled FINRA securities lawyer, securities arbitration lawyer that knows how to win these cases for brokers. And that's why I suggest you contact our law firm.